Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. Whilst waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Good afternoon, everybody. Welcome. Thank you for joining us for today's online talk entitled Common Challenges in Sub-Sale Transactions. My name is Mira Masho, and I'm an associate with Mao & Quiet & Associates, and I will be your moderator for today. Now, before we start with today's talk, allow me to introduce the firm and what we do. Now, Mao & Quiet & Associates is a mid-sized law firm that was founded in 1985 by Datuk Mao & Quiet. Our able team today comprises of 37 lawyers and a support team of 30. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, arbitration, and adjudication, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's online talk is part of MWKA's online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013. Some of which were also broadcasted live. But since the COVID-19 MCO, we have moved online in order to continue with our objectives in sharing knowledge, raising awareness, and encouraging networkings for clients, potential clients, and in-house counsels. Now, before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice for your matter, please contact us for a complimentary legal consultation. The details will be given at the end of this talk. Now, before I begin, allow me to introduce our speakers for today. We have two speakers. We have Mr. Vincent Cheng, who is a senior associate that is practicing in the area of real property transactions. He was admitted to the Malaysian Bar in 2018, and he specializes in acquisitions and disposals of real property loan documentations for financial institution tenancy and leases. He also has interest and practice in contract drafting, will writing, and inheritance matters. Our second speaker for today is Mr. Khairul Hakimi, who is also an associate practicing in the Real Estate Practice Department. He graduated with a Bachelor of Laws from Multimedia University and was called to the Malaysian Bar in 2022. His areas of practice includes real estate and loan transactions for the acquisition and disposal of property by individuals and corporate entities. Now, our speakers will be discussing these four talk points. Mr. Hakimi will be discussing the first talk point, which is the differences between developer projects and sub-sale transactions, whereas Vincent will continue with the other three talk points, which is the common challenges in sub-sale transactions, stamp duty, and general tips when purchasing properties. Now, with no further ado, let me proceed to give the floor to Mr. Hakimi.
Hello, everyone. Thank you, Mira, for the introduction of our firm and also what we do. I'm Hakimi. I'm an associate here at Mahwin Kwan Associates. And for our talk here today, I'll be presenting on the differences between developer projects and also sub-sales. In order to better understand the challenges faced in a sub-sale transaction, it is crucial to first recognize the differences between the two modes of property acquisition by way of purchase, which are by way of purchasing from developer projects and also by way of sub-sales. What is a developer project transaction, or also known as a direct purchase from the developer? A direct purchase from the developer refers to an acquisition of property directly from the developer. In this mode of transaction, buyers are purchasing properties that are newly constructed or is still under development, often sold off plan. Direct purchases are popular among buyers who are seeking for brand new properties with modern designs and concepts, and is still covered under warranties, since any defects will be covered under the defect liability period once the buyer receives keys to the property from the developer. And there is also potential room for customization of the property since it's an empty property. When purchasing from developers, they often offer discounts, incentives, rebates, etc. during initial sale phases. And this option is particularly appealing for buyers looking to secure properties in up and coming neighborhoods. In contrast, a sub-sale transaction refers to property acquisition from existing house owners in the secondary market, as opposed to buying directly from a developer. In most cases, sub-sale properties are already completed properties occupied or is held as investments by their current owners. Sub-sale transactions are a common option for buyers looking to buy property in already established neighborhoods or business centers. And these properties are generally sold on an as-is, where-is basis, where it basically means that is what you get. To further illustrate the differences between purchasing from developer projects and also by way of sub-sale transactions, let us compare them across four key aspects. Firstly, the transaction process itself. When purchasing from developers, buyers would purchase residential properties directly from a developer, which are usually new developments and under construction. In contrast, in sub-sales, buyers would purchase completed residential properties from existing owners in the secondary market. When purchasing from developers, buyers would typically sign agreements that adhere to standardized formats and are statutorily prescribed by the Housing Development Control and Licensing Act, also commonly known as the Housing Development Act. These agreements may be in the form of Schedule G SPA applicable to landed properties, or Schedule H SPA, which is applicable for strata properties, and payments are made according to the developer's progress billings, which are issued depending on the completion of the property. In contrast, also a crucial point to highlight for our discussion today is that in sub-sale transactions, the agreement does not follow any standard format. Instead, they rely on agreements that are carefully tailored and negotiated to suit the unique needs of the parties involved, which are the buyers and also the seller. Secondly, we can see that the payment structure for the two modes of transaction is different as well. When purchasing from developers, generally set a fixed price for the units, and the price is usually non-negotiable, but they often offer discounts, incentives, rebates during the initial phases. Typically, a 10% deposit is paid when the purchaser signs the SPA, with subsequent payments of the 90% remaining due to be paid to the developer based on the developer's progress billings, which the developer will issue based on the stages of completion of them building the property. In contrast, purchases by way of sub-sale is typically more negotiable since it is based on agreement between the parties involved. Because of this, there is a room for the buyer to propose an offer for the purchase price of the property, and the seller may consider the buyer's offer. Typically, a 10% deposit is paid as well upon the buyer signing the SPA, or alternatively, a 3% earnest deposit has been paid before signing the SPA to real estate agents representing the seller, and the remaining 7% will be paid upon signing the SPA, while the remaining 90% is usually paid in a lump sum within the completion period of the SPA. We can see that the documentations involved for the two transactions are very different as well. When buying directly from developers, buyers would sign SPAs that are standardized and are statutorily prescribed. Since it is a statutorily prescribed SPA, neither party can make any amendments to the SPA unless with approval from the ministry, and it is governed under the Housing Development Act, these SPAs. Typically, parties would sign agreements in Schedule G SPA format, which is applicable for landed properties, and Schedule H SPA format, which are applicable for strata properties under the buy and sell concept. In contrast, in sub-sale transactions, as previously highlighted, the terms of the agreements is determined by the parties involved and is tailored to suit the specific circumstances of the parties, the property, and also any encumbrance over the said property. These sub-sale agreements are generally governed by contract law and also the National Land Code. And since it is an agreement negotiated between the parties, each party can negotiate for terms which are favorable to themselves and protect their own interests. Another obvious difference between the two transactions is on property readiness or completion. For developer purchases, the transaction may take a longer time to complete. For instance, in the Schedule G SPA, it provides that the developer has to deliver vacant possession of the property to the buyer within 24 months of the SPA date, and under the Schedule H agreement, the developer has to deliver vacant possession within 36 months of the SPA date. The purchaser may also take a longer time before they can move into the property, since they may want to conduct further renovations to install built-in wardrobes and kitchen cabinets, and this may cause delay in entering the property. In contrast, sub-sale transactions may take less time to complete. For sub-sale transactions, the purchaser may have immediate possession of the property upon the transaction being complete, which is upon payment of the full purchase price being made. Generally, this form of transaction takes less time to complete, as freehold properties only may take up to 3 months to complete, while leasehold properties may take a longer time, between 3 to 6 months to complete, since government consents may be required. In sub-sales, the properties may also be likely in a move-in condition, since fixtures and fittings may be included as part of the sale. Now that we have identified the differences between developer purchases and sub-sales, and emphasized that in sub-sales, the terms of the agreements are freely negotiated between the parties based on the unique circumstances of the parties, the property, and also any encumbrance on the property, let us now explore the common challenges faced in sub-sale transactions. One of the challenges in sub-sale transactions is with the inclusion of the defects and as is where is basis clause. Unlike purchases from developers, where buyers do not have the option to inspect the property before the completion of the sale, sub-sale properties are typically inspected by the buyers prior to their purchase of the property. These properties are generally sold on an as is where is basis, meaning that the property is sold in its present state with all its existing faults, defects, and also issues. Buyers generally assume that this clause only applies to minor wear and tear, such as faded paint or scuffed floorings, and they may expect significant defects such as structural cracks on the property, water leaks, or faulty electrical wiring to be rectified by the seller. However, this is not the case, and unless specified otherwise in the SPA, the sellers are under no obligation to repair these defects before proceeding with the sale. This may create a potential conflict, especially when the buyer discovers hidden or latent defects once they have taken possession of the property. A well-drafted agreement can mitigate risk by including certain provisions, such as to impose responsibility to the seller to maintain the property condition until the handover is complete to the purchaser. It may also include provisions for pre-handover inspections, include defect rectification timelines, and also mechanisms for dispute resolution if any arise between the parties. Another contentious issue in sub-sale transactions is for the inclusion or exclusion of fixtures, fittings, and furniture as part of the sale. Typically, fixtures are items which are permanently attached to the property, for example, built-in shelves, which typically cannot be removed without causing damage to the property. Fittings are items not permanently attached but is installed or connected to the property, such as curtains or blinds. And furniture refers to movable property, movable items such as tables, chairs that are not fixed on the property and can be relocated easily. Disputes often arise between the parties due to misunderstanding between the parties on what was implied to form part of the sale. Some examples of items that may be contested are built-in wardrobes, televisions, aircon units, tables, and washing machines. The parties may also argue over whether fixtures installed by tenants residing at the property when the purchaser comes to view the property forms part of the sale. In this instance, the seller may argue that these items belong to the tenant and are not part of the sale. The vendor might also have made verbal assurances to the buyer during the property viewings when the buyer comes to view the property, and such promises to include specific furniture, but they may omit to include the furniture as part of the sale. If fixtures, fittings, and furniture are a concern of the parties, the SPA should clearly include a detailed list of inventories to prevent misunderstandings in the subsale transaction. A well-drafted SPA should also include an exhaustive list of items that will be included as part of the sale. While uncommon, the consequences of fraud in a subsale transaction can be devastating, especially in high-value transactions. Fraudulent activities can result to financial losses, legal battles, and even invalidation of the SPA transaction. Examples of fraudulent activities include where the fraudster may impersonate rightful owner of the property to sell it illegally, where the parties may use fraudulent documents such as forged title deeds, falsify identity documents to deceive another party into believing that it's a legitimate transaction, and also where sellers or its intermediaries misrepresent crucial details of the property, such as the size, category of land use, or encumbrance in an attempt to defraud the other party. To prevent fraudulent activities in subsale transactions, legal due diligence is crucial for subsale transactions. A solicitor's thorough investigation would ensure that a subsale transaction is legitimate and secures the parties' interests. The key due diligence steps includes conducting land searches to verify legal ownership of the property, the encumbrance, caveats, any restriction in interest over the property. We can also conduct background checks on the parties involved, including the sellers, the buyers, and all intermediaries, including identifying the capacity of each party. We should conduct bankruptcy search to identify that the parties are able to proceed with the sale transaction and examine all documents involved in the SPA, including examining all documents involved in the subsale transactions, including the SPA, title deeds, and financial agreements to look for irregularities or any sign of forgery. I will now pass to Vincent, who will be sharing the remaining challenges faced in subsale transactions and on stamp duty.
Thank you, Hakimi, for sharing the common challenges faced in subsale transactions and also to illustrate the differences between developer projects and also subsale transactions. And thank you, Mira, for the earlier introduction. So just to reintroduce myself, my name is Vincent, and I'm a senior associate at Mawing Quinn Associates. So moving forward, I'll be also sharing some other challenges that we may face in subsale transactions. So we have here point number 4, failure to comply with legal requirements. So as we all know, because subsale transactions involve different types of properties, it may be agricultural land, it may be residential land, and even among residential land, there can be freehold lands and also leasehold lands. And occasionally you may come across transactions where one of the parties, for example, the buyer is a foreign citizen. So therefore, subsale transactions are subject to various legal requirements, and failure to comply with these legal requirements can result in grave consequences, such as, for example, the transaction being delayed and then transaction being invalid outright, causing parties to have to spend extra efforts in rectifying these defects or even to call off the entire transaction. So for example, one of the legal requirements is that sellers must ensure that any encumbrance or caveats on the property are discharged or withdrawn before the transaction can be completed. So here, encumbrance refers to charge, or in simpler jargon, it means mortgage. So mortgages lodged by the bank on the title of property must be redeemed and fulfilled before the seller can get his original title back to pass on good and valid title to the purchaser. All right. And subsequently, we also have other examples, for example, the necessity to obtain state consent. So in most leasehold property transactions, you will see in the title that tanah ini tidak boleh dipindah milik dipajak. So this means that state consent is mandatory for these transactions. Otherwise, registration cannot be perfected at the land office. Also, we have low-cost properties where, depending on the state, so certain threshold must be met. So say, for example, the purchaser's household income must be less than 10,000 per month in a family in Selangor for them to be entitled to purchase certain types of low-cost properties in Selangor. And as I mentioned just now, there are some transactions involving purchasers who are foreign entities, for example, foreign citizens, foreign individuals, and also foreign companies. So in each of this scenario, state consent or even the relevant board of housing is required for these transactions to go through. And lastly, which is also very important for the sellers, compliance with Real Property Gains Tax Act is of absolute importance. So for most type of transactions, I would say all, the parties must actually file a return at the Inland Revenue Board, that means LHDN, within 60 days of the date of the SPA, which is typically the date that you see on the cover of the SPA. So even if the seller is not gaining any profit mathematically from this transaction, say for example, a transfer by way of love and affection between father and children, so the parties must nonetheless still file these returns at LHDN to comply with the Real Property Gains Tax Act. This is because failure may result in fines or monetary fines or imprisonment or both, resulting in grave consequence on the transferor and the transferee. And also we have land office presentations. So from time to time, what we see is that sometimes the title comes with certain defects due to incomplete documentation, non-payment of requisite fees on errors in the legal paperwork. So therefore, this would cause delay which are the transfer process, leading to frustration and potential financial consequences for the purchaser. For example, late payment interest, the need to pay extra fees and the likes. Okay, so it is therefore very important for lawyers to go through the documents, for example, ensuring that the owner of the property, or rather the seller of the property, has paid the quit rent and assessment and other taxes on the land before they submit documents to the land office for registration. And of course, we have seen also from time to time completion delays. So while not exactly common, delays in subsale transactions can be effectively managed through proactive planning and a well-drafted SPA. So by outlining the timeline that each party must comply with, say for example, the seller must provide this document within this period and the purchaser must pay this amount within this period, then when timelines are effectively clearly indicated in the SPA, potential issues can be addressed upfront and clear remedies will be found in the SPA that protects the interests of the parties and to ensure that the transaction is completed efficiently. So let's look at some common causes of delay. So as I mentioned just now, incomplete documentation. So say for example, the seller fails to provide his identity card, a copy of his identity card. Financing issues. Sometimes it's the purchaser's issues with his financing. Say, for example, he fails to meet his secrecy and CTOS requirements, causing the bank to withhold disbursement of the bank loan. And we also have other examples, for example, defects in titles and disputes. Very rarely, but still it may happen, such as you have incorrect details or outdated title particulars in the title. So as we know from time to time, years, the land office may eventually convert a provisional title called a hak milik sementara into what we call a final title, be geran or pajakan. And therefore, sometimes owners may not know that their titles have been converted from a provisional title to a final title, leading to the parties having some delays in completing the transaction. Therefore, to prevent this, lawyers regularly conduct land searches on the title to ensure that the title is valid before the parties actually enter into this transaction, and land searches towards the end to ensure that the title is good and valid to be presented to the land office. And last but not least, one of the challenges that people may face in subsidy transactions is reliance on generic agreements. Theoretically, parties may actually sell and purchase transactions without going through a lawyer, provided that they are cash purchases without the involvement of banks, because banks would typically require and mandate the involvement of their lawyers, which is typically on their panels. All right. So in certain transactions, this sale and transfer can actually be done through what we call a DIY transaction. But without knowing the intrinsic details in each type of property, each type of loan, sometimes people just adopt templates that they find on internet. Say, for example, sale and purchase agreement template. So this is what they key in on Google, and then they adopt without understanding that each transaction is unique to itself, and therefore resulting in mistakes that fails to address the unique needs of the transaction and specific requirements by the parties themselves. And therefore, such transactions require bespoke agreements tailored to the circumstances of the party, the property itself, and encumbrances on the property, which means a one-size-fits-all SPA or approach is usually insufficient. The templates that you may find on the internet may lack critical provision to comply with Malaysian property laws, leaving the parties vulnerable to dispute and non-compliance. So for example, as I mentioned just now, sometimes leasehold properties may require state approval. So if this part is not addressed in the SPA and the parties proceed all the way until the end, only to realize that, oh, I need this consent at the land office, and applying for consent, you need another 2 to 3 months for that. So who would bear the consequence and the late payment penalty for this part? So these are some of the examples that let us know why a proper and a tailored agreement is required in each sub-sale transaction. So extended time frame for sellers. So this is also one of the common scenarios that we face. So for example, the sellers of a property, the seller of the property may still be residing in the property that he intends to sell. And therefore, he requires a longer handover period, even after the purchaser has paid the purchase price. So if the parties are able to address this heads on in the SPA when the SPA is being negotiated, so this would have prevented a lot of disputes at the end of the transaction. So you wouldn't want transactions to turn sour in the midst or towards the end of the transaction. So let all disputes be addressed and let all needs be clarified at the front of the transaction in an SPA, clearly recorded, so that no one, if disputes arise, the parties can always go back to the SPA to see how these challenges can be remedied. All right, then we have another top point. As we all know, when you purchase, especially sub-sale properties, stamp duty is a huge amount that you have to pay if you are not a first-time buyer, especially. Part of our talk today will also be on how to calculate stamp duty and what are the stamp duty exemptions and reliefs that we have in 2025. So when we talk about stamp duty, is actually an umbrella term referring to tax and levies that the government impose on written instruments. For example, memorandum of transfer, loan agreements, tenancy agreements, or something as simple as a statutory declaration, the ones that you go for commissioner for oaths to declare something. This is also subject to stamp duty. But in our context, when it comes to real property sale and purchase, the stamp duty that we talk about usually refers to what we call as stamp duty on transfer of properties or memorandum of transfer. This is the current rate that we have for stamp duty on transfer of properties. So as we can see, the stamp duty for transfer of properties is a tiered rate. So that means it is not a one-size-fits-all or a one single flat rate applicable on all transactions. So you can see that for the first 100,000, the rate is 1%. For the next 400,000 value of the property, the rate is 2%. And then we have the next 500,000, 3%. And any amount in excess of 1 million is 4%. We have here an example. So if the property is sold at 1.5 million, then the stamp duty using the table just now. So we import the values here for the first 100,000, the next 100,000, the next 500,000, and the final 500,000. So using this, we will get a final figure of 44,000 ringgit. So it is also important to note that the amount that LHDN takes into consideration is not necessarily the price that you see in the SPA. So LHDN will take the consideration or the market value of the property, whichever is higher. So therefore, there are in certain transactions, people attempt to do what we call a markdown transaction, which is to declare a lower value in the SPA than it really is on the table. That means the parties actually pay more than what is seen on the SPA. So to curb this kind of not so honest transactions, LHDN will have their own team of valuers to educate the market value of the property, which they would then calculate the stamp duty on whichever is higher. If the SPA's price is higher than the market value, then they will still adopt the price of the SPA. So it is one thing quite interesting to note that stamp duty on transfer of properties to foreign entities is not subject to this table. Instead of having what we have here, 1%, 2%, 3%, and 4%, stamp duty on transfer of properties to foreign entities is subject to a flat stamp duty of 4% to foreign individuals and companies. So before this amendment that took effect in 2024, transfer of properties to foreigners was subject to the same stamp duty rate as Malaysian citizens. But starting 2024, stamp duty on foreign citizens for transfer of properties is subject to a flat stamp duty rate of 4%, which means on this table, if the consideration was 1.5 million, 1.5 million, you multiply by 4% flat and you will get a stamp duty amount of 60,000 for foreigners. All right. So after we know how to calculate stamp duty on transfers, so let's look at some stamp duty exemptions that are still applicable this year, 2025. So we have here Stamp Duty Exemption Order 2021 and Stamp Duty Order 2021 PUA 54/2021. So the first one, PUA 53/2021, is applicable on MOT, while PUA 54/2021 is applicable on loan stamp duty for loan agreements. All right. So these two stamp duty exemptions are still applicable, provided that the property that you're looking at is a residential property, which does not include SOHO, SOFO, SOVO, and more importantly, service apartment. Service apartment is a term coined when an apartment, a residential apartment, is built on commercial title, which unfortunately disqualifies it from being eligible for these two exemptions. So therefore, if you happen to purchase any residential property, which is a service apartment, it's important to be clear on what type of title it is built on. If it is built on commercial title, then LHDN's stance is that it is not eligible for this stamp duty exemption. And the SPA price or the market value of the property is not more than 500,000. So if you happen to purchase a property at 550,000, then sorry, unfortunately, you will not be entitled to this exemption. And the applicant must be a Malaysian citizen who has never acquired any residential property through any means. Any means here means that they have never inherited, been gifted, or bought any residential property. So if you happen to have already owned a residential property before the one that you are buying right now, even though you have sold this property, you will not be entitled to apply for these two exemptions. All right. And lastly, the SPA is executed no later than end of this year, 31st December 2025. All right. So this exemption is applicable to both developer projects and sub-sale properties. So you are not confined to only buying sub-sale properties if you want to enjoy these particular exemptions. And on top of that, we have another stamp duty exemption, which applies if you are transferring a property by way of love and affection between grandparents, parents, and children. So it can be from grandparents to grandchildren or from parents to children, provided that the recipient is a Malaysian citizen and the instrument of transfer is executed after April 2023. So one thing to note that full exemption of stamp duty only applies to the first 1 million of the value of the property. So that means at 1 million market value, you will not need to pay any stamp duty for this kind of transfer by way of love and affection between your family members. Another thing is that to note is that this exemption only applies if the transfer happens vertically from parents to children, from grandparents to grandchildren. It does not apply if the transfer is between siblings horizontally, from your brother to your sister, from sister to brother, no. So unfortunately, there is no exemption if the transfer is between siblings, all right? So any sum in excess of 1 million market value is still subject to stamp duty under this exemption, but there will be a 50% waiver on such stamp duty, which means the table that we were looking at just now, if it is a transfer between family members, vertical family members, So you do not need to pay stamp duty for these 3 tiers, but you pay a stamp duty of 2% at 2% rate for any amount in excess of the first 1 million. Okay. And last but not least, we have stamp duty exemption that applies if it is a voluntary gift, that means by way of love and affection, not a sale and purchase agreement, between spouses, husbands and wives, inter-divorce, that means not through an inheritance, but during lifetime. The attractive part about this exemption is it is full exemption regardless of the value of the property. So even at 10 million, you are still entitled to full stamp duty exemption if you go under PUA 420/2007. This stamp duty exemption has been in place for 18 years and it will still likely be going strong. So as announced in budget 2025 in October or November last year, we have here individual income tax relief on housing loan interest payment for their first residential property. So for people who are buying their first residential property, for each assessment year of their income tax based on the purchase price, they may be applying for this income tax relief of 7,000 if the purchase price is less than 500,000, or a tax relief of 5,000 if the purchase price is more than 500,000 but less than 750,000. So this relief is claimable for 3 consecutive assessment years on sale and purchase agreements completed between this year and up till 31st December 2027. Last but not least, we would like to also share a bit on stamp duty, some tips on stamp duty for property investments and joint purchases. So because stamp duty rates are never constant, for example, the table that we were sharing with you just now started from 2019. So before that, there was no 4% rate. So that means purchasers and home buyers need to be aware of latest stamp duty rates and applicable exemptions so that they can enjoy whatever is best for their interests. First-time stamp duty exemptions are a hit or miss. That means if you don't use this exemption for this first residential property that you are buying, you automatically lose your eligibility on your next property. You cannot save your exemption on this property to be used on this. No. So it's either you use this or not. So of course, you will want to use this for your first residential property. Likewise, in joint purchases, so say for example, you are buying this together with your wife. Both first-time purchasers will equally exhaust their first-time exemption. So you cannot keep your first-time exemption solely because you are buying this together with your wife and you want to save it for your upcoming property where you might be buying under your own name. No. So you have to use this exemption in your property. So you may then plan with your spouse or your siblings if you decide to buy property on joint names to see if it is really worth it to go with joint name, or you might want to save your stamp duty exemption for another purchase. So last but not least, we have general tips when purchasing properties, which we will I will pass this back to Hakimi for him to share with you.
Thank you, Vincent. We'll be sharing on some general tips when purchasing properties. Firstly, this is applicable when you are purchasing properties directly from a developer. You should always do background research on the developer. This applies for direct purchase from developers. You should always verify that the developers is a credible one. They have a valid license and a good track record in completing the project and also delays. In developer sales, the payments are made according to the developer's progress billings, and if the developer does not finish constructing the property, then that wouldn't be good for the buyer, because of course you would expect a vacant possession of the property. And because of this, when purchasing from developers, you should always do your background research that the developer always delivers on their work, and this would avoid any future troubles. There's also this website that you can refer to see the developer's details just to make sure that the developer is a valid one. Second, this applies always to sub-sale transactions. When you buy sub-sale properties, generally the buyers would always do an inspection over the property. And if you are interested in the property, you should always conduct a thorough inspection of the property, because when you buy the sub-sale property, you are buying it on the as is where is basis. That means that it will be sold in its current state. And whatever defects that comes together with the property, you would have to fork out your own money to repair any defects on the property. So you should always conduct a thorough investigation and be satisfied before you conduct the purchase. For example, if you have inspected the property the first time and during your initial viewing you do the property, you might as well just arrange a second viewing of the property and see everything thoroughly before you decide that you would buy the property. You should always see the condition of the property and also all the fixtures that comes together with the property, all the built-in cabinets, the wardrobes of the property that are already built in. You should be satisfied with the entire condition of the property. Next, you should always do background research on the title for the property. When purchasing property, you should always know what kind of property title it is. Is it a freehold property or a leasehold property? A freehold property where you hold the property indefinitely. A leasehold property may only be for a lease up to 99 years. And also another consideration for this is that leasehold properties may require government consents or state consents just to transfer leasehold properties, and you may have a slightly difficult time disposing the property. So therefore, this should also be taken into account when you are purchasing properties. You should also be aware of the express conditions of the property and make sure that the property is a property for you to stay in, and also check if there is any restriction in interest over the property to see if any government consents like tanah in pihak berkuasa negeri, that kind of thing. And also you should always identify that it is a property which is still held under master title, or if the individual title of the property has been issued. And also another thing is that when you buy properties and when the title is already issued, it is very easy to determine who is the seller. You can just see on the title of the property and see if the vendor's name is on the property. So that would confirm that the vendor is the owner of the property, and therefore you have determined that the seller is under a capacity to sell the property. Also, you should always check for ownership and maintenance costs. When buying properties, you should factor in upfront costs such as stamp duty to be paid when purchasing the property, and also long-term costs of the property such as bank installment payments and also quit rent and assessments. Quit rents are paid yearly and assessment are paid half years. And also the maintenance charges for the property. If you are buying a stratified property, there would be maintenance charges for you to pay, which depends on your priority. It may take a lot of sum just to pay the maintenance charges on a monthly basis, and therefore, when you inspect the property, you should always ask upfront how much is the monthly maintenance cost, how much money you would have to fork out on a monthly basis. Lastly, you should always engage in credible lawyers. You should always make sure that the law firm you are appointing or you are about to appoint to conduct your sale and purchase agreement or loans are registered with the Malaysian Bar Council. You should always verify that the lawyer in charge is a registered practitioner. So easily you can do an online check here at this website to check if the lawyer in charge for your matter or will be in charge for your matter is practicing. And you can also check if where the lawyer claims to be from is still an established law firm and is still operating. That's all from us.
Thank you, Hakimi. Thank you, Hakimi and Vincent. That was a very insightful session. I felt like I learned a lot from that talk. Now we'll be proceeding with the Q&A session. I believe some of the attendees have submitted their questions to us, to the speakers. Now allow me to begin. Okay, so one question that we received was, if the subsale property is still under the defect liability period, DLP, would the obligations of the developer to defect the repair will cease? Can I ask Hakimi to answer this question?
Yeah, thank you for the question. So if subsale properties is still under defect liability period, would the obligation of the developer to repair the defects cease? So I would assume in this case that the vendor has bought or is the person who has bought the property from the developer and now plans to sell the property within the defect liability period. So theoretically, the developer's obligations to address the defects over the property does not cease merely because the property is being subsold. However, in transactions where developers' written confirmations is required, developers may often impose a condition stating that their defect liability period obligations are therefore ceased. Ideally, the parties should include in the subsale agreement, since it's a mutual agreement between the parties. The purchaser or the purchaser's lawyer would likely want to include in the SPA, and also to get the vendor to agree to claim against the developer for the defects while the SPA transaction is still on.
Okay, thank you, Hakimi. The next question is from an anonymous attendee. On the RPGT, do we still need to retain the 3% sum and forward the said 3% sum to IRB if there is no gain from the sale made within the 5 years period? Vincent, would you like to answer this question?
Yes, sure. Thank you very much, Mira, for reading the question, and thank you for this interesting question that we have. Just to repeat the question, do we need to retain 3% retention sum and forward this to the Inland Revenue Board if there's no gain from the sale, even though the sale is made within 5 years period? Just a bit of context. If a sale happens within 5 years from the date of acquisition, so under the Real Property Gains Tax Act, this sale is subject to real property gains tax. But the key word here is if there's no gain. So if there's no gain in this transaction, the solicitors between the parties may agree to have it recorded in the SPA that retention sum does not need to be addressed in the SPA, therefore no retention sum, and it will not be forwarded to the Inland Revenue Board that will count for RPGT. So in this case, if the parties agree to have this recorded in the SPA, the vendor should also execute what we call a CKHT3 form for exemption of RPGT and go for paragraph capital B1, small letter b, B1B, which states that so if the vendor goes for this part as a reason for no CKH, then it can be filed at LHDN as a valid filing. Thank you.
Thank you, Vincent. Next question. Another anonymous attendee. If a purchaser owns a commercial property such as a shop office, is the exemption of stamp duty given to the purchase of a residential house below 500,000 still given? Vincent?
Thank you again, Mira. So thanks again for this question. So this question was what I wanted to emphasize just now when we were talking about stamp duty exemption. So under PUA 53 and /2021 and PUA 54 /2021, which are the exemption policies for this stamp duty exemption. So the term residential property is clearly defined in the Act to mean a house, a condominium unit, an apartment, or a flat purchased or obtained solely to be used as a dwelling house. And therefore, shop offices and even service apartments built on commercial title will not be entitled to this exemption, which applies only for residential properties built on residential titles, no matter the price. Thank you.
Okay, thank you, Vincent. Another question that we received was, is there any specific period that needs to be complied between the payment of deposit and the signing of the SNP in sub-sales transaction? Can I give this question to Hakimi?
Hello, thank you, Mira. It's an interesting question. So the question is if there is any specific period that need to be complied between the payment of the deposit and the signing of the SPA in the sub-sale transaction. So for sub-sale transactions, usually the payment of the deposit is made when the purchaser comes to sign the SPA agreement. Therefore, the specific period is at the time of signing the SPA, by the purchaser should make the payment of the balance deposit. And in usual circumstances, when buying properties under subsale, usually the purchaser would have already paid 3% of the 10% deposit as earnest deposit or booking fee to real estate agents, and the remaining 7% will be paid by the purchaser when they come to sign the agreements. Why we get the purchaser to sign the agreement first is because we would get the deposit sum, and also this deposit sum would be forwarded together with the SPA executed by the purchaser to the vendor, and the sums would be forwarded to the vendor when the vendor signs the SPA itself. However, there may be an instance that the buyer may require more time to make the deposit payment. Usually the 10% of the full purchase price is a big amount. So for example, if also because the sub-sale agreements are agreements based on mutual agreements, mutual consents of the parties, the vendor may also agree that if the purchaser wishes to maybe withdraw his KWSP money to pay the balance deposit, then they may agree that the balance deposit to be paid at a later time while they have already executed the agreement. Maybe you can set it a month after this agreement, the purchaser has to pay the balance deposit.
Thanks, Hakimi. Moving on to the next question. How does the buyer know the actual market value of the sub-sale property in the sub-sale transaction used by the LHDN to access the market value of the property, as the seller wishes to sell the property below market value to have quick liquidation for himself? Can I ask Hakimi to address this question?
Thank you, Mira. So how does the buyer know the actual market value of the sub-sale property in the sub-sale transactions used by LHDN to access the market value of the property if the seller wishes to sell the property below market value to have quick liquidation for himself? So the buyer can know the actual market value of the sub-sale property, for example, on online websites where there is property listings. For example, like in an entire development project or a property in a very specific area, you can always refer to websites such as Property Guru. They would always have an estimate of how much the property or property surrounding the specific property that the vendor is selling is priced at. And also they may appoint property valuers. You can pay to get a valuation report, and the valuation report would state that how much is the estimated market value for the property. Also, property agents, when dealing with property agents, generally they have a record of the purchase price history of the property. So in that way, you can actually know how much the actual market value of the subject property is and is used by LHDN to determine the market value.
On to the next question. Since we are limited on time, we will limit to the last two questions. So the next question is, for developer cases, do we still need to prepare the deed of mutual covenant or the DMC, knowing that there is already a strata title act now? Vincent, this question, can you answer?
Thank you again, Mira. So we have had developers who actually port the strata title regulations 1989 and the strata title act, the third schedule from the strata management act 2013 into what they call a DMC. So their DMC is in essence the third schedule, the bylaws under the strata management act 2013. That as it may, some developers would still opt for their own DMC, which I would say, therefore say it is optional because some developers may have extra facilities that they want to cover in separate agreements. So one thing to note for sure is that contracts cannot be used to override the law. So if the law has already provided something expressly this, then you cannot use a contract to attempt to circumvent the law. I hope this helps. Thank you.
Okay, thank you, Vincent. Last question for today is the inheritance tax enforced now for property tax transactions between a parent and a child?
Okay, thank you again, Mira. So we have this question from Mr. Lok. Thank you for the question. Inheritance tax was once a thing in Malaysia. Back in 1991, it was repealed. And since then, there has been no inheritance tax, although there have been calls to revive this particular tax. But for the time being, there is still no inheritance tax enforced in Malaysia. But things can change. So who knows, next year there might be. This is something that we cannot tell at the moment.
Okay, thank you, Vincent. Now with that, we have ended our Q&A session. Now before we end the talk, allow me to share my screen again. Okay, before we conclude, I have a few announcements to make. First, please join us again for our upcoming talk, which is going to be held on the 12th of March 2025, entitled Fraudulent Land Transactions and Title Disputes in Malaysia. The speakers for this will be Ms. Denise and Ms. Noel. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, do follow and like our social medias that are set on the screen. And fourthly, if you would like to speak with our lawyers, we offer a complimentary consultation for up to 30 minutes over the telephone or over video conference. Please fill in the form on our website. The link is posted in our chat box. Thank you for our guests for joining us for us today. We hope you have found today's session insightful. Thank you, everybody, and see you at our next talk.